On August 14, 2021, Christopher Harvey dialed 911 from the home he shared with his ex-girlfriend, Rodrica Hill. He claimed that he just got home and found his girlfriend gravely injured, and that the back door of the home had been left open. The evidence, however, painted a very different picture. According to the evidence, Christopher Harvey was not happy with the breakup, and he was not happy that Rodrica started seeing someone else. The state eventually charged Christopher Harvey with Rodrica Hill's murder, claiming that he murdered the young mother due to jealousy. His interrogation has gained popularity due to his commitment to the story that someone else did it, although he admitted that he was mad at Rodrica because she had brought her new man to their home. So this is Christopher Harvey's trial for the murder of ex-girlfriend Rodrica Hill. Representing the state are prosecutors Brittany Fox and Andrea Diaz. Representing the defendant, Christopher Harvey, are Assistant Public Defenders Brooke Brewer, Amy Lim, and Dina Duncan. At his interrogation, Christopher Harvey seemed unhinged, and his defense story seemed implausible. Let's see if he has a better defense at trial, with the help of 3 members of the excellent local public defender's office.
All right, let's go back on records. 2021 CF 2146, State of Florida versus Christopher Harvey. Defendant is present in the courtroom with his counsel, and all other counsel are present. So I guess yesterday we left off with the state concern that the defense would call a witness for the primary purpose of impeaching the witness. I think they said sole, but the rule's a little broader than that. You can't call a witness for the primary purpose of impeaching. However, if there's some factual information that comes out in that testimony, that's usually held to be permissible. So I guess I would just ask the defense not to do that. And then, but the only, I think, real corrective would be to, that happens, like strike the testimony or something. I don't know how you address that ahead of time. You just have to rely on counsel not to do that. Is there anything else we need to address before?
So I guess if we do show video, is it going to be either the video from the flash drive or the video that's in evidence, so we don't run into the issue we ran into yesterday with the internet connection and it being poor quality on the defense's part?
I mean, why wouldn't the state just give the defense the admitted exhibit editions so they can pull them up and it's labeled the right way? And
they didn't ask me for it. I could.
I mean, just as like a professional trial courtesy here. So when you bring this up, like I just showed the jury this, you can show the jury the same thing because you might have a different view on that thing. Like,
right. I mean, if they want to provide me with a flash drive, I'm happy to copy over my digital trial exhibit folder, but I don't think I'm required to provide them with a flash drive of it, and they've never asked me for it.
Yeah, I guess something with the address ahead of time for future trials.
The only other thing on particular Deputy Pye, again, I have asked Ms. Brewer if she's going to go into this and she wouldn't tell me, is he previously had an IA investigation that she brought up in depositions. That would be improper for her to bring up in his testimony.
I mean, that would qualify as impeachment.
It wouldn't under the case law. He was actually found not guilty of what the IA was investigated. And
I guess it depends on what was the issue.
It doesn't, not under the case law. And Ms. Diaz has that case law and can go over it with Your Honor if needed. But the evidence rules are very clear that a witness can be impeached with a prior misdemeanor crime of dishonesty or a prior felony conviction, and that IA investigations are not appropriate for impeachment to be put in front of the jury.
So if it were an IA investigation where a police officer was, if they're trying to determine whether or not he planted evidence or something like that, that would show potential bias of the witness?
Well, that's not what we have here, and I also think that that's correct. It would not be appropriate under all of the case law and rules of evidence. I mean, I guess if he had been convicted of tampering with evidence, then absolutely then he'd be a convicted felon.
I think we're talking about two different types of impeachment. You're talking about convictions and prior instances of bad conduct. I was talking about bias.
Well, I think it's one and the same under the rules and the case law. I mean, the case law is very clear that IA investigations are inappropriate and improper to be brought up in front of the jury.
Do you want to talk about what the investigation was about, or do you want to just try to roll on it as we go?
Well, I don't think they can bring up any mention of an IA investigation of any officer, especially when the basis of that IA investigation resulted in him being acquitted at trial.
What, like this kind of trial, or like an IA informal administrative proceeding?
No, the charge for Deputy Pye, he was brought up on charges, I think, in Liberty or Gadsden, and he was acquitted at trial.
Like an actual trial?
An actual criminal trial.
Do you have that case you want me to look at?
Yes, sir. Ms. Diaz can lay out the case law for you.
I have 4 cases, Your Honor.
Let me ask, I guess, before we get into that, defense, were you going to do that, I guess? Do we need to go into this further?
I'm just giving you
Let me ask the defense
Oh, I'm sorry.
what you're planning on doing with that.
Your Honor, I actually wasn't intending on getting into this kind of question.
Okay. So I think by agreement we can avoid that issue. Anything else to discuss?
Yes, Your Honor. I'm not sure. I need to speak to one of my investigators about which witness we will call first. One of my witnesses is going to be Gary Knight. I anticipate that he's going to say that he has known Mr. Harvey for 20 years, that he knows him personally, and can talk about his character. I will not introduce any of that during the trial. However, I would request to do a proffer of that outside the presence of the jury. Because he lives in Jacksonville, we transported him here for trial. And so should we get into a situation where sentencing is an issue, I would like that testimony to be considered by the court. Obviously, there's certain situations where that might not be important, but I would like to just handle it all today if the court would allow me to.
I mean, after the jury's deliberating, I'd be more than happy to do that.
Okay, so you wouldn't want to do it after his...
Yeah, I don't want to send the jury out and postpone the trial for that.
Yes, Judge. My only concern is he is supposed to catch a bus at 11 something. So I'll get the details on that. I don't believe that they've arrived yet. So I do have 2 other witnesses that I will call first. I intend for them to be rather quick.
You don't think Mr. Knight has arrived yet?
No, when I walked in, they were not outside. Only...
You're saying they. Which witness? Are you talking about Mr. Knight and whoever he's with?
Yes, he's with my investigator.
Oh, okay. So that's the they you're using there?
Pardon?
That's the they you're using is Mr. Knight and your investigator?
Yes, Your Honor.
And so that specific witness, you're not ready to call him yet?
They just got here. I was just informed they just got here.
Okay.
So that's my only concern is I just wanted him to be able to catch that bus back.
Yeah, I mean, if sentencing is an issue, I don't think the state would object to Zoom for that type of testimony.
Okay. I'm happy to do that too.
Okay.
Otherwise, there's no issues from the state. We're ready to, I mean, from the defense, we're ready to
Okay.
Could I just get a witness list, or if you can verbally provide it?
I have already provided it. It will be Gary Knight, Officer Pittman, I guess he's a sergeant, and Officer or Deputy Pye.
Okay.
You think in that order? Or?
No, Judge, I didn't realize Knight was here.
I mean, that doesn't matter. I have the names, that's fine. All right, are we ready to go?
Well, I just need to step outside for
Okay.
2 minutes.
Are they all here?
No.
Are there any issues? Besides- Okay. People do that real quick. Just put 3 or 4 in the bar and let them pass them around if they want. I don't know how I got up here. This drawer doesn't open anymore. I also have 2 pencils. Turn dirt now.
I just talked to them about what they requested. That's fine.
Okay, ready?
Yes, Your Honor, we're ready.
All right, let's bring her in.
Dana.
All right, please be seated. So before we continue, I just want to make sure we had the extra pads and pens down here. Is everybody good in that department? All right. So State, we left off with you.
I'm sorry?
You had to formally rest for the record.
Yes, sir. State rest.
Okay, thanks. And defense, your first witness.
Yes, Your Honor, may we call Gary Knight to the stand?
Good morning, sir. Just come on up here.
Can I say good morning to everybody?
Yeah, go ahead. If I could get you to just pause right there, raise your right hand, and face our clerk to be sworn.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Okay, then have a seat right there. And defense, when you're ready.
May it please the court. Good morning.
Good morning.
Can you please state your name?
My name is Gary Clinton Knight, Sr.
Okay. And Mr. Knight, do you know Christopher Harvey?
How you doing?
How do you know Mr. Harvey?
Used to work with him years ago.
Where did y'all work?
All over.
Okay, what did you do?
Concrete work.
All right. How long have you known him?
Quite a while. Quite a while. Quite a while.
What does that mean?
Years.
Okay, 10 years?
Or longer.
20 years?
Close.
Close to 20 years, all right. Did you see Mr. Harvey back in August of 2021?
I did.
Okay, and have we previously talked about the specific date that that would have been? Friday the 13th?
Yes.
Okay. And where were you living in August of 2021?
I was homeless at the time.
Okay.
I was living in the Days Inn Hotel.
All right. And did you happen to see Mr. Harvey that morning?
I saw him that morning. When I saw him, I was glad to see him because at the time I was homeless and I didn't have any work. And I know that they were
Objection, 10
working.
non-responsive.
We could just focus a little bit. Thanks.
Sure. So did you see Mr. Harvey that morning?
I did.
Do you remember where?
At the Sheriff's gas station on Appalachia Parkway.
So close by where you were staying?
Across the street.
Okay. And you said that you were happy to see him.
I was.
Why is that?
Because I knew that he did concrete work, and that's what at the time that's what kind of work I was doing.
So you were
I mean, I was like I said, I was homeless and I didn't have any work, and I was trying to find work, and I was glad to see him because I knew he knew some people that was working.
okay. Did you make arrangements to see each other later that day?
I did.
All right. Tell me about that.
Well, he asked me. He said, "Well, where you staying?" I said, "I'm staying across the street, man, because I'm kind of homeless. I'm paying a hotel fee." And he said, "Well, when I get off, I come through."
Okay. And did he?
Yes.
Okay. Do you know when he came through?
I don't. It's sad to say, but I can't recall what time it was.
Okay.
But I know when he got there, we sat there for the longest, reminiscing. And when he got ready to leave, he said, "Man, I'm gonna get on home because my old lady gonna be mad as hell. It's late." And he got in his truck and left, and I went on in the hotel room.
Okay. So I want to ask you a little bit about what happened when you were at the hotel with Mr. Harvey, okay?
Okay.
You said you don't remember.
I couldn't give you a definite time.
Okay.
And
Was
I
it?
was trying to think about it, but I'd be lying if I said I knew what time it was when he left, but I know it was late.
Okay. Was it nighttime?
Yes.
Okay. And you said it was a couple of hours that you were together?
Maybe longer than that.
Okay.
You know, we
Maybe a
just sat
few hours?
We could have been, but we just sat there. We sat there drinking. You
Okay.
know, just reminiscing. The boy talk. You know, talking about the jobs we done, and what they were doing at the time. They were working, doing slabs, still doing
Actually,
slab
it's a
work.
non-responsive and narrative.
All right. Continue, please.
Okay. And while you were sitting at the Days Inn drinking, did any police officers show up?
Yes,
Okay. Did you talk to them?
I did.
Okay. And do you remember what they asked you about?
The question was asked because he came up from the storage side. He was walking. When he got up close enough, he said, "Man, did y'all hear any gunfire?" And my answer was to him. I said, "Hell no, I ain't heard no gunfire. If I heard gunfire, I'm going in the room because the bullet ain't got no name on it."
Okay. So,
And he continued walking. He continued walking on around the hotel.
okay.
And we stayed right there sitting down talking.
All right. That night when you were hanging out with Mr. Harvey, was he angry?
No,
Was he upset?
about nothing.
How would you describe his demeanor?
We laughing and kicking it.
Okay.
Just kicking it like boys kick it.
Okay. Did he mention anything about having problems with his girlfriend?
Not to me.
Okay.
Not that I recall.
Okay. Do you remember if during the couple or few hours that y'all were drinking, did he stay the whole time?
Yeah. That I can remember.
Okay. Did you see him screech off in his truck?
No.
Did he come and go a bunch of times?
No.
So he was with you?
Yeah.
Okay. Did you ever see him knock on any doors?
No.
Okay. And you told me you don't remember what time he left,
I couldn't. I'd be lying to you if I tell you I do. I did.
but it was late
It was late.
or early morning.
It was late.
All right. That's all the questions I have.
State any cross?
Morning, Mr. Knight.
Good morning.
So your testimony today is that you met or saw Mr. Harvey at the Shell station earlier on August 14th, and that you invited him over to the Days Inn.
Well, he asked me where I stayed, and I told him across the street. He said, "Well, when I get off, I come through."
Okay. Do you remember giving an interview with Detective Blake Howard of the Leon County Sheriff's Office on August 14th, later that afternoon?
I remember a guy coming by, but I can't remember what we discussed.
Right.
But the guy did come by.
All right. If you had told him that you had no plans to meet Mr. Harvey that night, would that have been the truth?
Why would I say I had no plans to meet him when I talked to him that morning? I didn't think he would come by because people are busy. People have things to do. You know, just because they tell you that they're going to come by, it doesn't mean they're going to come by. But he just so happened to show up, and I was happy because I was trying to find some work.
Okay. So you didn't have plans to meet him that night. He just showed up.
I'm glad that he stopped by.
And I understand.
Whether it was plans to see him, I didn't know whether I was going to see him or not. Again, you know, people will tell you they're going to do something. That doesn't mean that they do it, but I was happy that he did stop by.
Okay. When you spoke with law enforcement, do you remember that you couldn't even remember Mr. Harvey's name at first because it had been so long since you'd seen him?
Till now, you calling him by his name. I couldn't tell you his name yesterday, but I know him by seeing him and working with him.
Okay.
I can't keep everybody's name in mind,
Sure.
but by face recognition, I know who he is.
Yeah, no, that makes sense. And do you also remember telling law enforcement that you hadn't seen him in 15 years?
I hadn't seen him in quite a long time.
All right. Does 15 years sound about right?
Could be, because I moved to Arkansas.
Okay.
From when I left Tallahassee, I moved to Arkansas.
All right. So he's not somebody that you were in regular contact with.
No.
He's not somebody that you would have considered yourself close with.
If you'd asked me that question 15, 16 years ago, I would say no. But, you know, working with somebody and you see him, it's been a while since you've seen him. It had been a while since I've seen him.
Right. No, and that's my question. So he's not somebody you kept in touch with?
No.
Okay. Y'all didn't maintain a friendship after he stopped working for that company you were working for?
What you mean? Explain that to me.
You didn't keep hanging out with him after you guys stopped working together?
No, we didn't keep hanging out. But if I saw him out, we would hang. You know, we'd chat. You know, kick it a little bit.
Sure.
Have a beer or something.
But you hadn't seen him in 15 years?
I hadn't seen him in a while.
All right. Do you remember telling police that you did not invite him over?
No, I don't remember telling the police.
You don't remember telling them that? All right.
Why would I tell him that when I asked him to stop by?
Okay. All right. So you did not invite him over. I'm sorry. Your testimony today is that you did invite him over that night.
I asked him to stop by. If that's inviting, that's inviting.
Okay.
I asked him to because I really wanted to find some work because my money was getting low and I didn't have a place to stay other than renting a hotel room.
For the record, I'm playing the audio recording of the interview with Mr. Knight and Detective Howard starting at around the 5-minute mark. So you told police you didn't invite him over and that you were surprised when he came by.
That's got me puzzled.
You need to hear it again? I
do.
Okay. Okay. So he said you didn't invite him over or anything, and you said no. Right?
That's what it sounded like I said. But I was sitting outside when he pulled up, drinking.
Right. So
I was
after
in the
he
room by myself.
after he showed up, y'all drank together. All right. How much would you say you had to drink that night?
Oh hell, I hadn't turned it on before he even got there.
Okay. So give us an idea. Is that a couple of beers? Is that a case of beer?
Baby, I hadn't turned it on, been drinking. But I know we sat there a while.
All right. He was drinking too?
Yeah.
Right. You said you had turned it on for a while. So you were, you had a lot to drink.
Yep.
Okay.
I've been drinking.
Is that part of the reason why it's hard for you to remember some things from that night?
Well, to be honest, I didn't know anything about this. In trying to reflect on that, it's just bits and pieces come to me.
Okay.
You know, but I didn't know anything about this up until I got a call.
All right. Do you remember if while you were there, Mr. Harvey pointed out a car different than the truck he drove in with? That he pointed out a car that he said was his?
I can't remember.
Can't remember? All right. If you told law enforcement that in your interview, would that have been the truth?
I can't remember.
The last time you saw Mr. Harvey, because you went inside, you went to bed, right?
Yeah.
Right, it was late. The last time you saw him, he was walking to his truck?
It's the last time I saw him.
All right.
He told me, I got to get on home, man, because my lady going to be raising hell. It's late.
Got to get on home.
I got to get on home.
All right.
So at that time, we dispersed.
All right. And he was talking on the phone while he was with you, right? Using his phone, texting, talking.
I can't recall that.
All right. You didn't know anything about his relationship with his lady, did
No.
you? No. Not something y'all talked about. Okay. So any drama that was going on with that, you wouldn't have known anything about it.
Not a thing. If I told you that I knew anything about that, I'd be lying to you.
Thank you, sir. No further questions.
Defense, any redirect?
He would be excused.
All right, thank you, sir. You may sit down.
I can go back to Jacksonville now?
Yes, sir.
Thank you, ma'am.
Defense, your next witness?
Now, we call Sergeant Hunt. I'm sorry, Sergeant Pittman. Thank you.
Morning, sir. If you could please come all the way forward, stop around there, face our clerk to be sworn.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? Yes, I do.
All right, and have a seat there. Defense, when you're ready.
Police Court. Good morning, Sergeant Pittman.
Good morning.
You were involved in a case on August 14th of 2021. Do you remember that?
Yes.
Oh, I'm sorry. Let me back up. Can you please introduce yourself?
Sure. My name's Sergeant James Pittman. I'm a sergeant of Leon County Sheriff's Office.
Thank you. And you were involved in a case off of Cathedral Drive in August of 21?
Yes, that's when I was working in the Violent Crimes Unit as a detective. I was not a sergeant at the time.
Okay. But you have since made sergeant?
Yes.
Congratulations. And in this scene, do you remember this event?
Yeah.
Okay. And we've talked about it before, right?
Yeah.
Okay. Your primary involvement was to get surveillance footage from a neighbor.
Yes, there was a neighbor's home immediately beside the scene, and there was a surveillance camera that he had on his house pointing towards the scene, and so I collected that video footage.
Okay. Do you remember the address?
No,
Okay. If I said it was 2828 Cathedral Drive, would you?
I wouldn't have a reason to think otherwise.
Yes, sir. So when I said that your involvement was to capture that surveillance, how did you do that?
So every surveillance system is a little bit different. It was just a home surveillance system, so I believe that one we were getting it by thumb drive, if I recall correctly, but I don't remember exactly. There's so many different kinds of systems and so many different ways of getting it. We did that a lot, obviously.
Okay. But you remember this surveillance?
I vaguely remembered the scene. I vaguely remember being in. I think the neighbor had his surveillance system on like a TV that he was looking at or something like that. But I don't remember very well. It was a long time ago, and I wasn't very heavily involved with that actual investigation.
That's right, because your primary role was to capture the surveillance.
Yeah, that was really just like helping out the detectives who were working that case.
Okay. Do you remember if when you watched the surveillance on a big screen TV, if there were multiple angles that you were looking at?
No, I remember there was just the one.
Okay, so there was only one, there weren't multiple.
Right.
And regardless of how many angles there were, you only captured one. Is that right?
I believe that's right.
Okay.
He may have had multiple cameras on his system. There was only one that was pointed towards the neighbor's house, towards the scene.
Okay. And then after you put it on the thumb drive or however you collected it, you never watched it again.
No.
Okay. And you certainly didn't critically analyze the video, right?
Certainly not.
Okay. You remember that it was a decent quality video,
Yeah.
all right? And that it showed some events that happened at nighttime,
Yes.
that the camera was looking through a line of trees or bushes.
Yeah, there's you could see the neighbor's house, you could see the neighbor's driveway, the cars there. But everything was looking sort of through some shrubbery. And I think it was a nighttime video too.
Okay. And you don't remember seeing any faces or anything like that on that video?
Certainly not.
Certainly not? Okay. And so you were kind of looking at headlights to see when people were coming and going. Is that fair?
I think that was the general idea. I don't remember specific. I didn't critically analyze the video like I told you. I don't remember exactly. I don't want to speak out of turn, but I don't remember specifically.
Okay. And there was another officer that was with you as y'all are kind of reviewing briefly the surveillance.
Yes.
And you take the information that you view and you take it to the officers who are next door and you tell them what you saw.
Can you say that again?
Sure. The two of you, as you're watching it, you go to the officers who are next door or detectives and you tell them what you saw.
I don't remember specifically. It may have, the deputy might have been doing that at that point, or I don't remember specifically if we communicated with them on seeing what was on the video or not.
Okay. But that's something that you typically do as officers. You
Sure.
tell each other what you're
Sure.
doing. Okay. So that wouldn't be abnormal if you did
No,
that.
it wouldn't be abnormal.
And your main question as you're watching the surveillance is, who's coming and going, right?
Yes.
Trying to capture that information.
Sure.
And you're making assumptions about someone being S1 or suspect 1.
Objection to leading.
Overrule.
I don't know if assumptions is a fair characterization, but we certainly are investigating.
Okay. Is it better to say that you're not sure who S1 is from the video?
I'm sorry, I don't understand your question.
Well, you didn't like assumptions, I understand. I didn't mean to. Is it better to say that you're unclear as to who S1 is as you're watching the surveillance?
Let me repeat what you said back to you. I don't think it would be, it was difficult to see specific persons in the video as far as who S1 was and who suspects and victims were in the case. I know that I know Mr. Harvey's name because it was on my subpoena, and I wouldn't have known it then. So as far as who people were in the video, wouldn't be able to tell you.
Okay. And so if you said someone's coming in and out of the truck all night, so I'm assuming it's S1. Is that fair?
Yes. Is that from the body-worn camera?
Yes, sir.
Okay.
So you have no reason to dispute that?
I wouldn't think so.
Okay. And you told us that you couldn't see any faces on the video, right?
No.
And you couldn't see any races?
Certainly not at night. Maybe
Okay.
during the daytime portion of it.
And you wanted someone to come back and get the whole 24 hours. Do you remember that?
I don't remember that very clearly.
Okay. Did you try to capture everything you could?
Sure.
Did you tell them they might need to come back and get some more?
That's probably.
All right. No further questions.
State, any redirect? Or sorry, cross.
What's the best evidence of what we can see on the video? I mean, is it talking to you or is it the video itself?
Certainly the video.
Okay. You weren't the lead detective on this case.
Absolutely not.
You didn't investigate the crime scene. You didn't interview any witnesses,
No.
right? You had a very limited role, right?
Quite.
Go to this location, get this video, and bring it back to us so we can critically analyze it and look at it and see if it helps us with our case or not.
Essentially.
All right. Nothing further.
Any redirect?
No, Your Honor. You need to excuse.
All right, thank you, sir. You may step down. State, or defense, your next witness.
Now, we would call Deputy Sean Pine.
Good morning, sir. Can you stand and face our clerk? Raise your right hand to be sworn.
Do you solemnly swear and affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, just have a seat here. Go ahead, defense.
Good morning.
Morning.
Can you please introduce yourself to the jury?
Sean Pine,
Okay. And where do you work?
Leon County Sheriff's Office,
What's your position?
Deputy Sheriff,
How long you been there?
since January 21.
Okay. Were you involved in a case off of Cathedral Drive back in August of 2021?
Yes,
Do you remember the date that you were on scene?
I think it was. Refer back to my notes. 8/14.
Okay. And is that your report?
Yes,
Great. So you wrote a report to document your involvement with this case, is that right?
yes,
And that report would have been given to other police officers, right?
Can you ask the question again?
Yes, sir. The report that you wrote would have been given to other police officers, or they would have had access to it.
At some point, yes, ma'am.
Okay. And in your report, you noted that Jerry turned over.
Objection to hearsay and leading.
Overruled. Go ahead.
In your report, you wrote that it should be noted that Jerry did turn over his phone to me to further prove his innocence.
Yes, ma'am, that's in my report.
Okay. Now, your entire involvement in this case happened on August 14th of 21,
Yes, ma'am.
and you viewed some surveillance video from the neighbor next to the scene.
Yes.
Okay. Do you remember the address of that neighbor?
I think it's 28 Cathedral, I believe.
Okay. And did you refer to your report for
Yes.
that? Okay. Did you know or learn that that was Mr. and Miss Williams' home?
Yes.
Okay. And do you know when you started watching that surveillance?
You mean what time it was at?
Yes, sir.
No.
Do you know what time you arrived on the scene?
No, I didn't notate that in my report.
Okay.
Time I arrived on scene.
And you were wearing body-worn camera on that day?
Yes, ma'am, I was.
And so if your body-worn camera shows that you started watching surveillance at 1:48 p.m., you have no reason to dispute that, right?
No, ma'am, I do
Because
not.
that's kind of the point of body-worn, right?
Correct.
Okay. Do you remember stopping watching the surveillance around 2 o'clock and going outside to relay information to other officers?
Yes.
Okay.
I don't know what time it was, but I do remember going out and speaking with, I think, with Sergeant Poole.
Pardon?
I was speaking to Sergeant Poole or the officers outside.
Okay, and so you go outside and tell Sergeant Poole what you watched on the video, right?
Correct.
And you said you don't remember that it was at 2 o'clock, but if it's on your body worn, you'd have no reason to dispute that, right?
Correct.
Okay, so that's about 12 minutes that you were inside watching the surveillance before you go outside and tell Sergeant Poole.
If that's what the body camera says. I don't know how many minutes it was, but that was one of the things they wanted to know why I was inside the house so long. They wanted to know, hey, why you still in the house? Let us know what's going on. So that's why, the reason why I went outside.
Okay, so you went in and out of the house to kind of relay information to the other officers who are next door.
Yes.
Okay. And the conversation that you had with Sergeant Poole didn't last very long, right? You went back into the house.
I'm not sure how long it lasted, but I did go back in the house, yes.
Okay. And if your body-worn camera shows that it was 3 minutes, you'd have no reason to dispute that, right?
No, ma'am.
Okay. And you relayed to Sergeant Poole that no other cars came throughout the night. Do you remember that?
If that's what I said on camera, I have no reason to dispute that.
Okay. And so then you went back in to watch some more footage, right?
Yes.
Kind of came back and forth, relaying information.
Yes, ma'am.
Okay. Now, were you somewhat relying on the neighbors to tell you what they saw in the surveillance?
We were reviewing the reviewing the camera system. It was their system in their house. And so they were actually running the system because it's their system. So I was like, okay, pull up this camera. What's that? So yeah, we were conversating back and forth. So yes,
Okay, and you're asking each other questions, right?
correct.
Did you see this? What is that?
Right,
And you're fast forwarding and rewinding, right?
correct.
Okay, and you weren't responsible for collecting that surveillance. So
No.
Sergeant Pittman did that, right?
Correct.
Do you have any idea of how long that surveillance was?
No, ma'am.
If I told you it was 15 and a half hours, you'd have no reason to dispute it, would you?
No reason.
Okay. So you said you're talking to the neighbors and you're saying, kind of talking about what you see on the surveillance.
Yes.
And you're wondering, are there any other cars coming and going? That's something you're looking for.
Correct.
Okay. Do you remember asking the neighbors to watch the surveillance after you left and let you know if they saw other cars coming and going?
If I said that on body camera, I don't have no reason to dispute that.
Yes, sir. Do you know if they ever called you?
Not to my knowledge. They never called me, no.
Okay. Did you leave them your phone number?
I might have left the sheriff's office phone number along with the case number.
Okay. But they never called you, right?
Never.
Because your only involvement was that one day.
Correct.
Okay. Now, at some point you confirmed that on the neighbor surveillance they could go back 72 hours.
I'm not sure about the hours, but okay.
Okay.
I'm not sure about how long it can go back or how long the footage is kept. That's what you're trying to ask me?
Yes, sir. And if that's something that you learned, did you notate it in your report?
No.
Okay. So if it's on body-worn camera, you'd have no reason to dispute it, right?
Correct.
Okay. Now, you'd agree with me that on that surveillance, it's kind of hard to tell what's going on.
Yes.
Okay. And there's some that you're looking at that's in the daytime and some that's at nighttime, right?
Correct.
Okay. It's easier to see the stuff that's happening during the day.
Yes.
But it's still somewhat difficult for y'all to make out what is happening.
Yes.
Okay. At different points in times, you think that there are people moving next door, right?
Yes.
And during the day, at one point, you think that a dog is a person.
If that happened on body camera, I have no reason to dispute that.
Okay. And you also think that a bush is a person.
If that happened on body camera, I have no reason to dispute it.
Okay. Now, you agreed that the footage was extended. I said 15 and a half hours, and you said you'd have no reason to dispute that, right?
Yes.
And so, do you remember how long you were on scene?
No, I do not.
Okay. Is it fair to say that you didn't watch all 15 and a half hours?
Yes.
Okay. And you were fast forwarding through the surveillance, right?
Yes.
Sometimes it was even in eight times the speed.
Yes.
Okay. And at some point, Sergeant Pittman, who was a detective at the time, came over and was watching it with you.
Yes.
Do you remember that?
Yes, I do.
Okay. And the two of you are kind of talking about, what you're looking for, right?
Yes.
And you're trying to figure out if he went back inside the house. Do you remember that?
He referring to?
Well, referring to anybody. I mean, y'all are trying to figure out who's coming and going from that house, right?
Yes.
Okay. So y'all are trying to figure out if he is coming and going.
Yes.
Okay. And you really are not able to make that determination, were you?
That a person came to the house or in the house? Which one are you asking?
Both.
But we saw a person come to the house, yes.
Okay. And you couldn't determine who that person was?
No.
Now, you never viewed anything other than the neighbor's surveillance. Is that right?
Yes.
You didn't watch any Ring camera, right?
No, ma'am.
And you didn't do any follow-up?
No, ma'am.
And you didn't ever go back to that scene?
No, I did not.
Okay. Now, just one moment.
No.
Deputy Pye, was Sergeant Poole a supervisor of yours?
On that day, yes, ma'am.
No further questions.
State, do you have any cross?
Just briefly. Deputy Pye, and that's PYE, right?
Yes, ma'am.
Just for the record. Your role was really limited in this case, right?
Yes, ma'am.
Okay. When there's a big scene like this, do duties get divided up between deputies and detectives?
Yes, ma'am.
All right. So your job was go meet with the neighbors and look at the surveillance video, see if you can see anything, right? And then we'll have another officer come out and actually physically collect it.
Yes, it kind of happened like that. It was, yes,
Okay. Who alerted you that there was surveillance video?
the neighbor.
The neighbor. So the neighbors were already, I guess, looking at their cameras and thought they saw something that might be relevant to this investigation.
I'm not sure how that part came about,
Okay.
but the neighbor approached me and said, hey, you might want to come look at the video.
Might want to come look at the video we have. All right. Were, some of the things that you wrote down in your report about saying, Harvey pulls into the driveway at X time, was that in part to the neighbors who knew Mr. Harvey and knew his truck and were talking to you about that's him pulling into the driveway?
Yes, ma'am, and I could see it was the same truck that I saw earlier in the video.
Okay.
The same style truck.
So you also had a frame of reference because you were at the original scene.
Yes.
Was it your job to take the video back to the department and sit down and analyze it and run through every single second of that video?
No, ma'am.
Whose job would that have been?
I probably would be Detective Pittman.
Okay. Or one of the detectives that was working?
Yes.
Okay. Is it usually the responsibility of the lead detective on a case to go through, watch the video, that type of thing?
Yes.
Okay. So anything that you were working on, that was just what you were looking at in the neighbor's house with their help of what they were seeing?
Correct.
Okay. And you gave a pretty detailed account of what you were able to see in your report, right?
Yes.
Right? It wasn't is that a bush or a dog, was it?
Right.
Okay. You were able to see Mr. Harvey's truck
Yes.
pulling into the residence, right? You were able to see some movement of one individual around that truck, right?
Yes.
Okay. You were able to see Miss Hill's vehicle there at the residence, right?
Yes.
Right? Her vehicle never leaves, does it?
At what point?
After Mr. Harvey arrives.
No.
Okay. You were able to see Mr. Harvey then leave the residence, right?
Yes.
Okay. And you were also able to see in the daytime video Mr. Harvey pull back in before calling 911, right?
Yes.
Okay. And you looked for that in that video to see if at any point or any other cars pulling into the driveway, right?
Yes.
And there were none.
No, ma'am.
Okay. Any other cars pulling into the yard area? Because you could see part of that, right, in the video.
Yes, ma'am.
Okay. None, right?
No other vehicles.
Okay. And so you got the video. You're standing by with the neighbors. Sergeant Pittman collects it, and then your role is done at that point, right?
Yes, ma'am.
Okay. Prior to going over and collecting the video, when you were originally on at Miss Hill's residence outside, because you never went inside, right?
No, ma'am.
Okay. You were also one of the deputies that was standing around with Mr. Moore, right?
Yes.
Okay. You didn't have any kind of previous relationship with Mr. Moore, did you?
No, ma'am.
Okay. But he was making some statements. He was telling you guys about what he had heard Mr. Harvey tell him, right?
Yes.
Okay. And he told you that Mr. Harvey told him, I killed her,
Yes,
right?
ma'am.
Right. And again, that was something that he was volunteering, because y'all weren't interviewing him, right?
No, ma'am.
Okay. How would you describe Mr. Moore's demeanor?
He was trying to figure out like what was going on, why was he here.
Okay.
Best way to describe it, he was kind of nervous and scared.
Right. And was he cooperative with you?
Yes, ma'am.
Well, I mean, you were only with him for a limited time, right?
Yes, ma'am. He was cooperative.
All right. Nothing further.
Defense, any redirect?
Yes, Your Honor.
Go ahead.
Deputy Pike, you wrote a report, right?
Yes.
And you have it in front of you, right?
Yes, ma'am.
And in the report, you listed out specific times of exactly what you saw in that video.
Yes.
Okay. And there's a number of different events that happened that you documented. Okay. And this information was relayed to the lead detective on the case. Is that right?
Yes, ma'am. Well, he would have access to my report.
Okay. So are you making the distinction that you didn't tell him, but that he would have had access to this?
Both. We were talking about it as we were looking at the video, me and Detective Pittman. But as far as the specific times, he would have been able to look at my report once it was submitted to be able to look at everything in detail.
Okay. Was it your understanding that Detective Pittman was lead?
I don't know who was lead.
Okay.
I still don't to this day know who was lead.
Yes, sir. So if Pittman was lead, you spoke to him, right?
Yes. I spoke to the detective that came to collect the video.
Yes, sir. And if there was somebody else who was lead, you didn't speak to them?
Correct.
Okay. All right. That's all the questions I have, Your Honor. He may be excused.
All right, thank you, sir. You may step down. Defense, any other witnesses right now? We'll take a break.
Yes, we would like to break.
Okay, let's do that. And then I just ask our jury not to discuss any of the testimony that's been given or your thoughts or opinions on the case, and we'll come back in 5 or 10 minutes after a quick comfort break. All right, the jury is out, and then please be seated. Has the defendant made a decision whether or not to testify? Will the defendant be testifying, Ms. Brewer?
No, Your Honor.
All right, Mr. Harvey, I just want to ask you, just so I make sure that you understand your right to testify in this case. You understand that it's entirely your choice on whether or not you testify in this case? If you could just pull that microphone over toward you.
Yes, sir.
And nobody can make that decision for you, correct?
Yes, sir.
So while you may have discussed that possibility with your attorneys, it's ultimately your decision on whether or not to testify in your own case?
Yes, sir.
All right, and then having considered everything, sat through the trial, discussed with your attorneys, everything that you've considered for that decision is your decision not to testify in this case?
Yes, sir.
All right. So I guess then the defense have any other witnesses?
No, Your Honor.
And so you can rest when the jury comes back in for the record and state what are you thinking for rebuttal, if any?
Done.
Okay, so then I think we should revisit the jury instructions.
Yes, sir. We're on version 4, right? Just want to make sure I'm opening the right one. I think it's 4.
Yeah, I think that's right. So I guess the first comment bubble there on heat of passion. Defense, do you have a position on that?
Sorry, Judge, the comment bubbles, do I need to open up, are they in track changes or?
Yeah, you have to change, if you go to review and change what you're looking at, so under tracking, you want to look at all markup. You might have simple markup, because I think Word defaults to that. You want to click all markup, and then you'll be able to see the comment bubbles. It's just,
Okay, I have, so the first bubble is on page 4.
yeah,
Got it.
it's just the heat of passion instruction. That's all it is.
Yes, sir.
So defense, do you have a position on heat of passion?
Just so I'm clear, under excusable homicide, number 2 is. I'm sorry, I can't hear you.
Very careful.
So you're saying it's also included in the excusable homicide instruction, and therefore it should be included in second-degree murder?
Yes, Judge. So we're fine with the instructions as they are and are also fine with the additional instruction of heat of passion that the state has described to not be included.
So you do not want to define what heat of passion is?
I'm sorry, Judge. I'm misunderstanding.
So it starts with, an issue in this case is whether Christopher Harvey did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. Then there's 5 criteria for that, and then there's if you have a reasonable doubt with regard to heat of passion, you should find him not guilty of second-degree murder. Like, that's kind of confusing way to say that. You should.
Judge, I apologize. I misstated earlier. We would be asking for that additional instruction for further definition.
And state, do you have any arguments that you want to make regarding that?
So, I mean, as it is now, I think is it in the comments for only second-degree murder, or is it?
Well, I mean, that was a placeholder I had for it, so that's where I was thinking of putting it. Where do you think it should go?
Well, no, I don't think it should go anywhere. I don't think they're entitled to it. But the standard instructions have it as give only if there's evidence that the defendant acted in the heat of passion on legally adequate provocation for first-degree murder and second-degree murder. I need to check the standard manslaughter. I'm not sure if it's in there or not. It's not. So I think it's only second. Yeah. So
written first-degree murder and second-degree murder as give only if there is evidence that the defendant acted in the heat of passion on legally adequate provocation. I think we were talking about two different things earlier. At least the defense was it stays inexcusable homicide. That's a standard instruction that I think it's reversible to edit that. What I'm talking about is under first-degree murder and second-degree murder in the standard instructions, give only if there's evidence that the defendant acted in the heat of passion on legally adequate provocation, which negates first-degree murder and second-degree murder and the elements of that. The case law that I placed on the record last time, as well as the defense in this case, that he didn't do it, I'm not sure how there's any evidence that the defense that would support.
I don't know that I have that case law. I don't recall looking at it. Do you want to put that on the record again?
Yes, sir. Taylor versus State, 316 Southern 3rd, 420. That's the 1st District, 2021.
I'm not saying you didn't, I just don't recall. So defense, do you have what evidence you think would support that instruction?
Yeah, if I could just have one, I just got to be up there.
Yeah, so the question defense is what evidence in this case would go toward heat of passion?
Yes, Judge. It appears from the state's evidence and their theory of prosecution is that based on the text messages and phone calls between purportedly Mr. Harvey and Ms. Hill, that there was anger, there was strife, that he had been drinking, he had perhaps been drinking heavily. This is what the state is asserting is their theory of prosecution based on the evidence that's been before the court. And based on that, Your Honor, I believe that there is enough evidence for the jury to consider a heat of passion element. And
Well, it's a heat of passion partial defense, right? So it doesn't sound like you guys are going to be arguing that, though.
Judge, I believe if I can find the paragraph, there was a statement in the case that the heat of passion is well established in Florida, and this is at 427, as a complete defense, and then describing if the killing occurs by accident, or as a partial defense to negate the element of premeditation.
Yeah, that's what I just said. So a partial defense to negate premeditation or depravity. And so that was the state's point. It would probably go on both if it was going to go included. But it doesn't sound like you guys are making that argument, was my question.
Judge, I believe the argument could be made.
Well, is it being made in this case? We're at jury instructions right before we charge the jury. So is that going to be a defense that comes up in this case?
Judge, I think based on the state's evidence, there could be an argument that if the jury does not determine that there was a premeditation to find first-degree murder, that they could consider that there was a heat of passion that would eliminate the element of premeditation, bringing it down to the second degree.
So, the answer to my question is, I guess, you're not going to make that argument, but the jury should still be instructed on it if they want to go that route on their own?
Okay. Yes, Judge.
There could be like a lot of different legal principles that would apply to this case that theoretically the jury could go, but point of the state charging would be to kind of narrow those, and then your defenses would be kind of on the other side of that. And so I think by this point in the case, we'd have an idea of the two sides of the case and then the law that's applicable to what the two sides think happened. Right? We're not instructing on the jury on every theoretical possibility.
Judge, I do agree with you that we're not instructing on every legal possibility, but because there is evidence present in the trial for the legal argument of heat of passion, it is our position that it is proper to instruct it to the jury.
So your view on that evidence is the defendant was not you're conceding any of these points, but that the defendant was drinking, there was an argument regarding the relationship that night, and what else?
Judge, so our argument for this instruction is based on the state's evidence.
Right. I was just trying to get what is that evidence?
Okay, yes, Judge. So the evidence that has been presented at trial is that there was alcohol involved. I believe at one point the state was asking one of the police officers if Mr. Harvey was drinking alcohol on scene when they arrived. I believe it may have been Officer Machinez. There was the presentation of the text messages and call logs that the state is asserting were between Mr. Harvey and Ms. Hill.
All right, so just to pause for a moment. So we have alcohol and text messages. Text messages, I agree, would tend to support the defense. But the alcohol, I don't understand what element of heat of passion that would factor into.
Judge, I think the argument that the state could be asserting here is that, now I can't remember verbatim, but I believe the question may have even been, was he drinking a lot of alcohol? I know it was at least was he drinking alcohol? So the argument could be that he was maybe in a heightened state of passion based on his alcohol consumption, and then would have behaved in such a way because of his mental state with any alcohol consumption.
So it doesn't kind of, I mean, the heat of passion defense is, which I kind of feel like it tends toward a jury question, but the evidence that would need to support it is a sudden event, right? So drinking alcohol over a long period of time, I don't think helps element A. And then a reasonable person would have lost normal self-control. I don't think you can put in the subjective intoxicated person in that element. I don't think intoxication helps the blind, unreasoning fury, also in element B there. There was not a reasonable amount of time to cool off. Again, drinking over a period of time wouldn't seem to help that analysis. And then a reasonable person would not have cooled off, and Chris Harvey was in fact so provoked and did not cool off before he committed the act that caused the death. So I just don't see how alcohol factors in to the heat of passion.
Judge, may I have a moment?
Yeah.
Judge, so even without, if I'm understanding what the court is finding here, even without alcohol consumption, we still have the dialogue that the state is asserting is between Mr. Harvey and Ms. Hill, and in addition to that, the assertion that there were tires screeching and leaving the parking lot and coming and going at the Days Inn and coming and going at the Cathedral Drive address, all of which could be an indication of a heightened emotional state.
Judge, I would point out that the first DCA as well as the fourth, the first cites it in the Taylor case, specifically says arguments alone are insufficient to constitute adequate provocation. And it cites the fourth DCA that says marital squabbles do not constitute reasonable provocation required for the heat of passion defense. And that's also in Augustin versus State 244 Southern 336 from the fourth DCA in 2018. They found that giving the instruction in that case was harmless error, but the court specifically said if however, if there's a retrial in this case, the instruction should not be given, and that the trial court erred in giving the heat of passion instruction where there was no evidence to support it.
You're talking about Douglas?
No, Douglas is one. I was just referring to Augustin.
Augustin cited in Taylor too?
I'm not sure if Augustin cited in Taylor, but
What year is it, Augustin?
2018.
Can you just give me the site then, I guess?
Sure. 244 Southern 3rd 336.
326?
336.
Judge, if I could briefly respond.
Yeah, go ahead.
As far as the facts in Taylor that the state was pointing out, as well as the citation to a marital squabble not rising to the level of heat of passion, Your Honor, the facts in Taylor are about an argument between the appellant and his partner. It appears that there was an argument, a disagreement over money on the morning of the shooting. And that's at 424. as far as what we have here, Your Honor, it's not merely, from what the state has presented, not merely an argument between Ms. Hill and Mr. Harvey. It would be that there are other dynamics at play here. We have Mr. Crumby, who is at the hotel with Ms. Hill and who is with her and has been with her before, and who may be with her throughout the entire evening. So we have this other dynamic going on beyond what's described in Taylor, beyond what is a mere marital squabble. And so what we have is distinguishable, and we believe it is a question for the jury to decide whether there was a heat of passion, and the instruction should be given for their consideration.
Yeah, I think it's closer to a jury question in this case. There's infidelity that night, so then the question is, how long do you have to cool off? I think infidelity is the classic example of heat of passion defense. So I think at that point it becomes a jury question.
But Judge, the cases specifically say marital squabbles do not constitute reasonable provocation.
The definition of marital squabble, I think, is the issue there. We can look at the facts of each of those cases and kind of see where ours lies as. Maybe it's on the spectrum closer to squabble versus a sudden event. But I'm going to go ahead and get an instruction. And I think with the defense raising the issue, the intoxication, I think probably be appropriate to give the voluntary intoxication instruction. I think I'd just give that before reasonable doubt. That's kind of like the last substantive instruction.
Prior to weighing the evidence?
No, right before plea of not guilty.
Oh, right, yes, no objection to that.
That's fine, Judge.
It's just that one paragraph. There's a lot of stuff in the standard about before 1999. But those 5 or 6 paragraphs don't apply. It's just that it's not a defense to any crime instruction, right? That first paragraph.
Judge, could we have the instruction number, please, so I can double check it on
Yeah, it's 3.6D.
Thank you.
They hide them all over, so.
Would there's the give when other applicable crimes are general intent crimes?
Yes, I look at that and I still think it applies to the before 1999 instruction, because then that one's going back and forth between specific and general intent. But if you look at the first paragraph, it's the first sentence at the end. It says is not a defense to a crime. I mean, it's just not a defense. And so I think that's the one that applies after 1999.
Yes, sir.
Yeah, I think that's right. But I mean, I grant it is a little confusing the way it's written there. But
We agree with you, Judge.
all right, any other? Oh, I'm sorry. We still had culpable negligence issue. Any argument on
given the definition of culpable negligence, I believe there's evidence to support it, and I'd be asking for it.
Could you provide the instruction number for that as well, please?
I'm not going to be able to do that as quickly.
I'll look at the same time.
It's just a standard manslaughter instruction.
Yeah, it's built into manslaughter. It's one of
Okay, I should have it then.
it actually, I mean, it is the standard manslaughter, but there's 3 different prongs, I guess, for manslaughter. And so yeah, it's 2A, 2B, or 2C, and 7.7 manslaughter. And the instruction that was circulated only had 2A, but there's also, and there's no procurement evidence, so I think 2B is pretty easily eliminated. And then it's 2C, the death was caused by the culpable negligence of the defendant. And then there's a lengthy paragraph defining culpable negligence. I guess there's actually 2 paragraphs, but they're both in the comment section of the comment bubble that on the instruction I circulated.
Judge, as far as the 2C paragraph under 7.7 manslaughter, we don't have an objection to that.
Okay, so it'll read then just the way I circulated it. There's 2 elements, and 2 will be or element that intentionally committed an act or caused by culpable negligence.
Yes, sir.
And then there's 2 definitions or 2 paragraphs rather to define culpable negligence, and that's all in there now. All right, and then anything else we need? I guess let's talk about weighing the evidence, 6 through 10. I think there's some general inconsistent statement. I don't know if it was done the 4.0 way, but the prior inconsistent statements definitely came up.
Yes, sir. Class not be included.
No felony or misdemeanors.
No, sir.
Pressure, threat, or preferential treatment. I don't know if that
No, sir.
defense, do you have a different view on removing 6, 7, 9, and 10?
No, Judge, we agree that 8's applicable.
All right, so that's now paragraph 6, and the rest are removed. And then which of the defendant not testifying instructions, or both, would the defense like?
We would like both, please.
Okay. All right, is there any other comments on, we could just worry about the initial instructions for now? Okay, so that's version 5. I'm circulating that right now, and then I'm going to go ahead and print, and I think we'll just pen and ink if there are any changes now. Or do we have anything else?
Just as it relates to the heat of passion defense, I'd like to put one more case on the record. I think Your Honor previously mentioned it, the Douglas case, 652 Southern 2nd 887, 4th DCA, 1995. Those facts are somewhat similar to the facts that we have in this case. The court held the heat of passion was not applicable. On the day of the killing, the police were called as a result of domestic argument, which had risen out of a dispute between appellant and his wife regarding long-distance telephone charges. At 6:30, things had calmed down. At 6:30 p.m., things had calmed down, but appellant's wife wanted appellant to move out. Appellant agreed to leave and moved his clothing and belongings to the home of a friend and neighbor. There was disagreement as to who would have use of their one car, but it was finally agreed the appellant could take it. Later on, at midnight, an officer returned and found the appellant's wife's body in a pool of blood behind their vehicle. She had multiple, I don't know if it was stab wounds from a sharp object. And I believe the defendant, like in the Taylor case and I'm not sure about Augustin, the defendant testified. So the defense in that case was arguing, there was evidence to support it, and the court still said, no, the facts in this case only show marital squabbles, and it was insufficient. I think that's what we have in this case as well. It would be like if the defense were saying, well, the victim's DNA is on the gun, so we should get self-defense too. They don't just get anything that could potentially be available to say, jurors, look, if you believe that she was attacking him and he did this in self-defense, then you should find him not guilty. They don't get it that either. And I think heat of passion is the same way based on all of the case law. And it's improper for the court to instruct the jury that that's a legally available defense to the facts of this case.
Okay, thank you. All right, so let's take a comfort break, and then those are printing.
Thank you, Judge. How long?
It'll realistically take me at least 10 minutes to get them printed.
Okay, so we're back in time for you.
Yeah, there's more jurors and 7 with verdict forms. It's going to take a bit.